5 seconds to go. Start. The evidence of a hostile witness complainant stands on a different footing than the death of the complainant or the non-availability of the complainant. It was submitted that when the complainant turns hostile, the evidence of the shadow witness would play a vital role, as he can also tender primary evidence with regard to the demand of illegal gratification. Similarly, Nayan Kumar versus State of Maharashtra 2015-11 SCC 213 was relied upon to buttress the fact that if the complainant turns hostile, the conviction is permissible on the basis of presumption and other evidence. On the other hand, in B. Jayaraj, the acquittal was based on the fact that the complainant had turned hostile and there was no other witness to support the case of the prosecution, and hence there was lack of evidence against the accused. In C.P. Rao, the acquittal was based not merely on the non-availability of the complainant but the fact that there was previous animosity between the complainant and the accused, and also on the ground that money was thrust into the hands of the accused. Similarly, the accused was acquitted on the ground that the witness had turned hostile and the demand was not proved. So also in the case of M.R. Purushottam. Learned Counsel Sri Aristotle also made reference to C.M. Sharma, wherein the conviction was upheld even though the shadow witness was not present when the demand for illegal gratification was made and the amount was paid and there was recovery of tainted money. So also in Prakash Chand versus State Delhi Administration 19793 SCC 90, when the shadow witness turned hostile, the conviction was based on the evidence of other witnesses. Therefore, even in the absence of a complainant letting in his evidence or the complainant turning hostile, the case of the prosecution would not collapse, and the prosecution can only prove the case beyond reasonable doubt if there is other evidence to prove the case. Before answering the question under reference, we deem it necessary to clarify on one aspect of the matter, and that is with regard to hostile witness. Learned Senior Counsel Sri Nagamuttu submitted that the expression hostile witness must be read in the context of Section 154 of the Evidence Act. Section 154 of the Evidence Act states that the court may, in its discretion, permit the person who calls a witness to put any question to him which might be put in cross-examination by the adverse party. It further states that this section does not disentitle the person so permitted to rely on any part of the evidence of such witness. For immediate reference, Section 154 of the Evidence Act is extracted as under: the court may, in its discretion, permit the person who calls a witness to put any question to him which might be put in cross-examination by the adverse party. Nothing in this section shall disentitle the person so permitted under subsection 1 to rely on any part of the evidence of such witness. The said section was amended with effect from 16th April 2006, and subsection 2 of section 154 was added from the said date, while the original section was renumbered as subsection 1 of section 154. Learned Senior Counsel Sri Nagamuttu submitted that when the prosecution examines a witness who does not support the case of the prosecution, he cannot be declared to be a hostile witness and his evidence cannot be discarded as a whole. Although permission may be given by the court to such a witness to be cross-examined by the prosecution as per subsection 2 of section 154 of the Evidence Act, it is not necessary to declare such a witness as a hostile witness. This is because a statement of a hostile witness can be examined to the extent that it supports the case of prosecutor. In this regard, our attention was drawn to Satpal versus Delhi Administration 1976 1 SCC 727, which is a case arising under the 1947 Act, wherein this court, speaking through Sarkaria judge, has made pertinent observations regarding the credibility of a hostile witness. It was observed in paragraph 30 of the judgment that the terms hostile witness, adverse witness, unfavorable witness, unwilling witness are all terms of English law. At common law, if a witness exhibited manifest antipathy by his demeanor, answers, and attitude to the cause of the party calling him, the party was not, as a general rule, permitted to contradict him with his previous innocent statements, nor allowed to impeach his credit by general evidence of bad character. It was observed in paragraph 33 that the rigidity of the rule prohibiting a party to discredit or contradict its own witness was to an extent relaxed by evolving the terms hostile witness and unfavorable witness, and by attempting to draw a distinction between the two categories. Stop.